Hello and welcome. I'm attorney John Logan, and today we are at the offices of the Connecticut Bar Association for a discussion about a most timely topic: the importance of an independent judiciary bound only to the rule of law. With me here to discuss this topic are two extraordinary Connecticut lawyers, Wesley Horton and Stanley Twardy. Attorney Wesley Horton is known as one of Connecticut's foremost appellate lawyers. In his remarkable career, he has argued approximately 140 cases before the Connecticut Supreme Court, many of which involved pressing constitutional questions. He has also argued a constitutional law case before the United States Supreme Court. He is a past president of the American Council Association and serves as the president of the Connecticut Supreme Court Historical Society. Wes also has an over 4-decade tenure serving on the Connecticut Bar Association's Committee on Professional Ethics, 10 years of which was as the committee's chair. Our second panelist today, attorney Stanley Twardy, is of counsel at the prestigious law firm Pitney LLP. His practice is focused on helping clients with criminal, civil, and regulatory investigations. Stan has argued many civil and criminal cases before both state and federal appellate courts, and has been counsel of record in several cases before the United States Supreme Court. Before entering private practice, he served as the United States Attorney for the District of Connecticut and was Chief of Staff to Governor Lowell P. Weicker, Jr. Gentlemen, thanks to both of you for being here today.
Our pleasure.
I'd like to start asking just a very basic question. When we talk about judges being bound only to the rule of law, what does that phrase rule of law mean? Wes?
Yes, well, rule of law describes any country where the government itself follows its own laws and its constitution. And when there's a question about whether they've done so, they accept the judgment of the courts. That's the rule. That's the basic definition of the rule of law.
So contrast that with other styles of government.
Well, other styles of government are where the government decides what to do on the spur of the moment, and you never know what the law is going to be from day to day. It's basically the whims of the government, and the government doesn't follow its own laws unless it feels like doing so. Usually, you call that some kind of autocracy.
Fair enough. When you were the U.S. Attorney for the state of Connecticut for those years, or maybe even when you were the Chief of Staff to Governor Weicker, there must have been some times where the clash between the courts and the government had occurred.
Oh, it happens quite frequently. And in our country, the courts serve as a check on the government, on the executive branch, and on the legislature. Many of the cases that Wes has argued in the Connecticut Supreme Court have dealt with cases like that. But at the end of the day, it's important that the executive branch, and I was, as U.S. Attorney, part of the executive branch, and as Governor Weicker's Chief of Staff, part of the executive branch, it's important that the executive branch follows what the courts say that they're doing, that they should do.
Fair enough. So describe, if you could, sort of the relationship between the rule of law and the concept of democracy itself. Because democracies are the idea that the majority of the people can get what they want through their elected representatives, and it sort of seems like sometimes the rule of law gets in the way of that.
Well, first of all, it's usually democracy that resulted in the Constitution that decides what form of government you're going to have. So it's the people who have set up the Constitution in the first place in order to decide how the government is going to be run. So that's the ultimate reason, why the government has to follow the Constitution, because it's the people that set up the Constitution. So if the people don't like their Constitution, then obviously they can change it, and many times that's done. But until they do so, the government needs to follow the Constitution that the people themselves set up as part of democracy.
So the relationship between the rule of law and democracy, if the concept is that we have people that are electing our representatives and they're representing the will of the majority and the elections have been won, how does that work with the rule of law if the rule of law ends up standing in the way of what the people really want?
Well, the rule of law does not stand in the way of what the people want, because the people are the ones who have written the Constitution on which the whole government is based. So if the people think the Constitution should be changed because they want to do something the Constitution prohibits, then obviously they can do so. So democracy and the rule of law work very well together.
Yes, I'm picking up on what Wes just said. We have had amendments both to the United States Constitution and to the Connecticut Constitution, which reflect how people think at certain times. And interestingly, in our country, the Constitution is set up to actually make sure that there are rights for the minorities. It's not all majority rule. The minorities are protected. That's part of our tripartite system of government that we have here. The checks and balances between Congress, the courts, and the executive branch. And that's all in our Constitution. And it was done purposefully because our founding fathers saw what was going on in England and realized that you needed to have some checks and balances.
And obviously, with a tripartite form of government here, the sea changes are not as extreme as they might be in a parliamentarian form of government, where there is no constitution that may put the guardrails in place. How about just from a standpoint of business deciding? Do I want to be involved? Let's say American business wants to go to a foreign country. How important is it for them to have an understanding of that country's rule of law and how they function?
Well, certainly this has to do, to a large extent, with contracts.
Okay.
Businesses want to know if they enter into a contract with somebody in a foreign country, is the foreign country's legal system going to abide by the law of the contract, or is it going to favor somebody in its own country, or is it going to, even if it's two people in your own country, is it going to be swayed because of influences other than the rule of law?
And I think it's important, as Wes is pointing out, that when a United States company goes into another country, they want to make sure that they're protected. Okay. Now, we've had expansions of Pepsi, for example, into Russia and China. I don't think you would say that those were really good rule of law countries. But before they went in, and I was not involved with this, but I happen to know people who were at Pepsi. When they went in, they spent a lot of time getting to know the government officials. So they had a feel as to what would happen should a problem arise in that country.
Got it. If we sort of look at it from a standpoint, Stan, about supporting the judiciary, how well can a judiciary feel comfortable or feel supported when there's no public confidence behind the judiciary?
The judiciary is not going to feel good, and the country's not going to be functioning very well either at that point. We have seen over the last 2 or 3 decades in the media references to who appoints a judge at the federal system, not in the state system. I think, Wes, I can't remember anybody ever writing, it was a Weicker appointed judge or a Rowland appointed judge, but we're seeing that now in the federal system. And I think that undermines the public's confidence in the judiciary. And as a result, I think it undermines the public's confidence in their government.
Yeah, I see. In Connecticut, I think there's great confidence in our judicial system for one reason, because they're not elected, which also applies to the federal system. And the second reason is there doesn't seem to be a huge amount of partisanship in the courts. You don't think of right-wing judges or left-wing judges or Democratic-appointed judges. At least I do a lot of appellate work, and I hardly remember who appointed whom on the court, and it doesn't seem terribly relevant.
That's true in the federal system too, where I spend most of my time is, whether it's judges here, judges on the Second Circuit Court of Appeals, you don't think of them as appointed as a Republican or a Democrat, because we are very fortunate in this state, with our federal and state judiciary.
I agree.
The earlier in my career, I remember appearing in front of judges who had in their prior to the black robes life been a prosecutor, and I would be representing criminal defendants and wondering whether or not they could be fair, and always found actually, if anything, they bent over a little bit more towards the defense. They knew what the abuses there could be on the part of the state and did that. But what about these states that have elections, that there's a large amount of money going in? How comfortable can a litigant feel going into a courtroom where your opponent may be a corporation and the corporation supported a PAC that put $200,000 into the funding of the particular judge you're now appearing in front of.
Obviously, you can't feel very confident at all. I think it's just a horrible situation when judicial candidates basically have to run partisan campaigns, which is certainly what it looked like out in Wisconsin. I mean, I just can't imagine how that's good for judicial independence, and I can't imagine how that's good for public confidence in the decision.
In the impartiality of the decision.
Yeah, exactly.
Yes.
Yeah.
Go ahead.
No, I was going to say, I think you're right, spot on, Wes. Just think about it. If you've contributed to person A to become a judge, and person B is elected the judge, how are you going to feel when Judge B is taking one of your cases? It's one of those things that becomes very difficult.
There is another side to that, and that is that it's very important for terms of judges not to be short, so that they're not worrying about being thrown out of office because of some decision they made at a particular time.
Well, that's an interesting point that you just raised, and that is even in Connecticut,
Yeah.
I do recall a long time ago there was a judge that had ruled in a particular case involving an unfortunate situation where a young child had been killed by a driver who had an open can of an alcoholic beverage in the vehicle, but was not under the influence. Otherwise, apparently, the judge felt that this particular individual's background was warranting a pretrial diversionary program, and granted that program. And there was a huge outcry against that judge's decision. That judge went through a reappointment process, and it ended up being one decision that made the difference between, and the judge was reappointed, but the point is it makes one decision that people focus on, even though it was 8 years of thousands of decisions that judge had made. How do you try to buttress against that and provide some sort of clarity that judges need to make the calls that they make, balls and strikes?
So, John, you raise a good point. While our judges, state court judges in Connecticut are not elected, they are appointed by the governor, and their terms run out after 8 years, and they can be reappointed. So I think it's important here in Connecticut that you have a governor and you have a legislature, I should say, who will take that into account. That they understand that judges have to call balls and strikes, and sometimes you might disagree with a call. But if the judge is a good umpire, and gets most of the calls right, that's the type of person you want reappointed.
Yes, and I think it's very important when it's an 8-year term, and it's a rare event when there's a problem, but when it does come up, it's the obligation of lawyers to stand up for that judge in the reappointment process and speak up loudly and attend the hearings and point out to the context and make sure the legislators are not just talking about one particular event that everybody's all upset about.
Do you hear tale of assignments of cases being altered or changed because a judge is getting close to the reappointment process here in Connecticut? So I'm not going to give you that very difficult and controversial and highly public case, Stan, because you're coming up in a year. And so I'll give it to somebody that just got appointed to the bench.
I've never heard of that, Wes.
I've never heard of that at all. In fact, in one situation I was involved in 25 years ago, actually speaking out in favor of the judge, he had actually been given a very controversial criminal case to handle just before his 8 years was up. And he did a fine job on it, but he got into all sorts of brouhaha.
Fair enough.
But was reappointed.
So we do see in today's day and age an awful lot of partisan, both sides against judges. Is it starting to, in your view, starting to influence judges and how they decide? Not necessarily looking at the facts and the law, but sort of perceiving what the overwhelming public sentiment is on a case?
I've not experienced that with any judges I've appeared in front of, either in the federal or state system. And again, as I said earlier, I think we're really blessed here in this state with the quality and independence of the judiciary, that we have here.
I agree with Stan. I haven't seen that at all in the Connecticut state or federal courts.
Okay. Outside of the state, are you seeing cases where you sort of feel that there's maybe not a clear view of what the facts are, as opposed to disagreeing with the outcome of the law just because you intellectually disagree with that, but you accept the results? Are you seeing cases where you feel that the facts are being skewed?
I've not seen it, but that's sort of a difficult thing to do from outside of the state, because it's always being filtered by the media. And I'm not anti-media, don't get me wrong, but there is that filter. You're not there, you're not in court day in and day out watching what's going on. So it's really hard to say that I've seen that.
Then I'll turn it around this way. Is the media giving us a fair view of judges?
I think it probably depends upon the reporter, to tell you the truth. I don't think you can paint it all one way or the other.
I subscribe to both the Wall Street Journal and the New York Times.
So do I.
And when they agree, I figure, well, I guess it's okay. And when they disagree, I try to figure out which is more likely to be right. I'll say this about the decisions that have bothered me out of state are some of the reapportionment decisions I've seen in the past few years, where some courts seem to go back and forth depending on who was recently elected to the state Supreme Court in that state. And I know the Wisconsin situation is specifically on that subject, and it's just awful. I'm not saying either side is wrong, or they're being skewed because, they may feel honestly they're making the right decision on the law. It just looks bad, some of the reapportionment decisions concerning gerrymander cases.
And I guess the concept is that if it can flip-flop that easily because of one justice on a Supreme Court for a state, how do you have certainty for what the rules are going to be? Isn't that the whole idea of the rule of law, is to create some certainty for all of the players?
Well, that gets back to the whole issue of original interpretation of the Constitution or statutory interpretation by the judges. It's not, the judges don't make up the rules as they go along. The Congress, the legislature passes statutes, passes legislation that is then interpreted by the judges. I guess there's a body of common law has evolved, but we now have Prosser on torts. We have all these treatises that explain what the common law has evolved into. So it's not really the judges that decide what the law is. They interpret it. And you are right, though. I think if it hinges upon one person being elected to the Supreme Court, you don't know exactly how they're going to interpret certain things.
So how do you get beyond that? How do you, I mean, theoretically there's a yin and a yang, if you will. You have judges that are interpreting the statutes, and if the interpretation of the statutes isn't what the legislature presumably felt that was the intention of it, then the legislature can presumably go back and try to alter that law. That's the way the system is supposed to work, but sometimes it doesn't work that way.
It doesn't sometimes. I just, and that it goes back to the issue that you talked about, and as Wes came down on it, there's not a great deal of confidence in an elected judiciary. I mean, where's the checks and balances on that judiciary? At that point.
I will say this: one thing that increases confidence, it may be somewhat ironic, is when a justice whom you expected to come out one way ends up coming out the other way. To give you one specific example is Justice Gorsuch's decision. He was the fifth vote on the case, the gay rights case a couple of years ago. It was interpreting the meaning of the word sex in sex discrimination statutes at the workplace. And I had talked to a number of my liberal friends, who were complaining about Trump's choice. And then I mentioned this one case, and oh, really? Isn't that interesting? And all of a sudden they feel more confidence. And I've heard some people say that, and obviously it works in the other way too. But there's nothing that increases confidence more when somebody comes up with a decision that's contrary to what you thought politically they would be likely to do.
So, presumably, interpretation of constitutions, either state constitutions, which you have an enormous amount of experience with, or the United States Constitution, is where there can be some real sea changes in how the law goes forward. We saw that recently with Roe versus Wade being completely. What happens when we have precedents like that get reversed? What's the positives and the negatives of that?
I think the positive of it is it reflects where society is at the time. The negative is it undermines the credibility of the public in the judges. And Roe v. Wade, being reversed was because we have Republican justices who were involved in that, and so I think that sort of undermines what's going on. But the pendulum does swing, over time. And we, Dred Scott, was overturned. I mean, there are things that where the court comes in, and it's good to not be so bound by stare decisis. That there should be some grounding in that, but it shouldn't be the rule forever. It's not set in concrete. When a decision comes down, doesn't have to be that way forever, because the country has changed, the world has changed, and I think it's important that justices do bring their knowledge of what's going on in the world, in the state, to bear when they're making their decisions.
You mentioned Roe versus Wade being overruled. And I think one thing that increases the confidence of the public in general in the Supreme Court is when they don't go further than they have to go in deciding the case. I think in that particular situation, the Chief Justice said, I would have, he only voting for himself, said, I would have decided that particular case without overruling Roe versus Wade, because there was another basis on which the case could have been decided that wasn't so controversial, namely that Mississippi had only banned abortions, I believe it was after 16 weeks. And while you may not agree with his decision if you were in favor of abortion rights, there would have been less of an outcry on the subject if they had been a little more modest in what they were deciding.
Well, I want to wrap it up. I just want to, do you have any ideas as to what either we, the public or the media or the legislature or the judges could do to try to make it so that they don't feel improper influences or feel insulated enough? Maybe it's just they know it when they're doing it. I don't know, but any ideas that you have on what we can do to make that sure that the judges are independent and bound to the rule of law?
Well, the most important thing we can do as lawyers is explain to the public, as the three of us are doing right now, the importance of the rule of law. It's far more important than what the particular issue is, whether it's Roe versus Wade or anything else. It's far more important, because the last thing you want is for the United States to become like the baseball game with no umpires. When all that happens in that situation, as soon as there's a rhubarb, the stronger person wins, not the right person wins.
And I think Wes hit on something very important there. I think we as lawyers, in our conversations with lay people, have to remind them or explain to them the importance of the independence of the judiciary, and they are calling them as they see them. And different things come to bear as the umpire is making the call.
That's right.
Thank you, gentlemen. And I think that's going to wrap us up. The goal here is to make sure that we all show respect for the judges and let them call the balls and strikes as they see fit based upon the rule of law.